here.
Terrible job.
Under your leadership, General Holder, the DOJ has reached historic settlements with major banks and institutions. There was the $13 billion settlement with J.P. Morgan for its packaging and reselling of toxic mortgages leading up to the financial crisis. There was the $25 billion agreement with the nation's 5 largest mortgage servicers for widespread foreclosure abuses. There was another $2 billion settlement with J.P. Morgan for its role as chief banker in Bernie Madoff's multi-million-dollar Ponzi scheme, and a $1.9 billion deferred prosecution agreement with HSBC Bank for laundering money for Mexican drug cartels and conducting transactions with Cuba, Iran, Libya, and Burma. But I want to return to something that Mr. Nadler brought up earlier. And I'd like to also return, I gather as has been a theme this morning, to another hearing that was held before this committee, in this case 3 years ago, when we first learned that the DOJ was launching a $1 billion lawsuit against Deutsche Bank and Mortgage IT for repeatedly defrauding taxpayers when seeking insurance for bad mortgages. As you know, that $1 billion suit was eventually resolved in a $200 million settlement. And we had an exchange that, though it's awkward, I just feel it's necessary to walk through. I had asked whether the department would pursue criminal charges that could result in jail time for the heads of these larger banks and services, and you had responded that if there are individuals who have taken actions that would warrant individual liability, that's something that we would pursue. So I pointed out that under Sarbanes-Oxley, the statute provided for knowingly making false claims, one would be subject to fines of $1 million, imprisonment of up to 10 years. If the claims were willful, the violations were willful, fines of $5 million, and jail time of up to 20 years. And I asked if that would be the basis for potential claims, to which he responded, there are other statutes that we can bring, some as old and tried as true as wire fraud and mail fraud. There are a whole variety of tools that we have, including those that you've mentioned, and we will try to make use of all of those as we continue these investigations. I then asked that given the vast array of potential claims that could be brought, that would bring the potential of criminal violations. When will we expect to see the cases filed? To which he said, all I can tell you is we're looking seriously, we're going to pursue them aggressively, and as soon as we can make a determination and share that with the American people, we will. The possibility that those cases could be brought is certainly the case. We're in the process of looking at them, and it is possible that criminal prosecutions will result. It's now 2014, and not a single high-level executive with these financial institutions have faced criminal prosecutions. In fact, many of the settlements that DOJ has reached with these companies have absolved the individuals of ever answering to criminal charges. Now, the settlements that I referred to focus on actions by individuals at firms whose actions nearly brought down the United States economy. They're not minor infractions. They didn't happen by accident, and it's difficult to believe that this illegal activity happened without the knowledge of any executive at any of these financial institutions. Indeed, it's difficult for many Americans to have full faith in our criminal justice system when none of the principals, none of the decision makers of these companies have been prosecuted, have been taken to court, have been tried before a jury. And I just quote one more quote from Judge Jed Rakoff, senior U.S. District Court judge, who said, companies do not commit crimes, only their agents do. And while a company might get the benefit of some such crimes, prosecuting the company would inevitably punish directly or indirectly the many employees and shareholders who were totally innocent. Moreover, under the law of most U.S. jurisdictions, a company cannot be criminally liable unless at least one managerial agent has committed the crime in question, so why not prosecute the agent who actually committed the crime? We've seen many large settlements, General Holder, some that resolve to resolve the claims of illegal actions. But as Judge Rakoff points out, companies don't commit crimes, only their agents do. And to date, we haven't seen any criminal convictions of executives in those companies. And I'll ask what I asked 3 years ago. Is the department pursuing or going to pursue criminal claims against the people at these companies that committed the crimes that were the basis of the large settlements that were reached, the crimes that many Americans are still recovering from today?
Well, it is still the position of the Justice Department that there's no institution that is too big to prosecute, no person who's too important to prosecute. As I indicated in a previous answer, there have been individuals prosecuted from J.P. Morgan, Goldman Sachs, Morgan Stanley, Credit Suisse, UBS, Rabobank, ICAP, Galleon, SAC, Stanford Financial Group, all cases that have been brought against not those companies, but against individuals. The $13 billion agreement that we worked out with J.P. Morgan Chase has a carve-out that allows us to pursue criminal charges against individuals. And so
But General Holder, just
when we
before
have
I
the
finish,
capacity to make cases, we'll make them.
But in all of those cases that you listed, I appreciate the individual claims being brought against those claims against individuals. But to date, none of the executives, none of the decision makers at any of these companies have been held accountable.
The gentleman's time has expired. The chair now recognizes the gentleman from Ohio, Mr. Jordan.
I thank the gentleman. Mr. Holder, I sent you